Guys, welcome back to Neuronify. This is me on the other side, and I am very excited today because we are starting a new series, which is FMTUT series. Our previous series would be continued in different playlists, and I would be making a different playlist for this series also. This series particularly focuses on university tests because my UT is approaching, and I want you people also to join me in revising FMT. So in this series, every video would contain all the important questions from that chapter. So one video would contain one chapter, fine. So we are starting with the very first chapter without wasting any further minute, introduction and legal procedures. So you might be knowing these are the important questions. I mean star marked questions. Summon recording 6 questions are there. So in this video we'll be just quickly understand the 6 questions. In next video we'll be understanding questions of that chapter. So I thought ki this series would help all of us. So yeah, we'll begin the video now. What are the questions? 6 questions are there, one by one we'll see. First is summon, then recording and blah blah blah. Yes, so we'll just start it. So very first question is summon, or which is also called as subpoena. Summon is to call, sub is under, poena is penalty. Now you'll understand it by definition. Summon or subpoena is defined as a written document, written in duplicate and signed by the presiding officer of the court, compelling the attendance of a witness in the court under penalty on a specified date and time and for a specified case. So what is the definition? Summon or subpoena is nothing but a written document. It is just a written document. Second point is it is written in duplicate. This is one of the MCQ, and it is signed by presiding officer of the court, compelling the attendance of a witness in the court and under penalty on a specified date and time. In simple words, it is nothing but an invitation for a witness to come in a court. But this invitation carries penalty. That is, if the witness did not attend the court, then he or she would be punished. So in simple terms, you just remember the points. Ki number 1 point is it is a written document. Number 2, it is written in duplicate. Number 3, it has got penalty. So these 3 words should be present in your definition. That summon is defined as a written document, written in duplicate and signed by the presiding officer of the court, compelling the attendance of a witness in court under penalty on a specified date, time and for a specified case. Now this is common sense. Every case will carry separate summon. So you can add that point also in definition. Just sit quietly, listen to the session, and it is going to help you a lot in time crisis. Just listen to the questions carefully. Number 1 point, you have to write the definition. Number 2, the court may also request the medical officer to bring books, case records or medical legal reports of the patient. Obviously, if we are going to be doctors tomorrow in future, and obviously we would all be asked to present our cases, MLC or say medical legal cases in the courts. So obviously we are going to bring books and case records and medical legal reports of the patient. So these are not required, but to increase the length of answer, these sentences are very important. So what you'll write, main thing, definition, written document, duplicate and penalty, and the this extra line that court asks doctor to bring books and case records. Fine. Now what is penalty? When a summon is issued, the witness is expected to attend the court unless there is a reasonable excuse for absence. For a medical man, the reasonable excuse may be that he himself is not well or that he is busy in rendering emergency medical care. It is simple English. I think all of you would be able to understand this. If you are not attending, then obviously you are going to be punished. Same thing. So when a summon is issued, the witness is expected to attend the court. Now moving ahead, not obeying a summon entails penalty, which means you will be punished. In a civil case, these sections are not important actually. The sections which are given in bracket will be covering entire sections, complete list at the end of this series. So I'm just skipping this section because I just want to make this video crisp and short and beneficial for revision. So in a civil case, the witness has to make the good the loss to party, which means if this is a phrase, to make good the loss to party. Now what does this mean? If the witness is not going to attend the court in civil case from the same party which called the witness, then he or she has to pay the compensation to that particular party. let's say A party has called witness B to give evidences in favor of A, but B cancelled it, B denied it, and B didn't attend the court. So B has to pay financially to A group, because it was B's party was A actually. In simple words, understand, good the loss to party means you have to, if you are not going to attend the court, you have to pay financially, you have to pay some amount to the same party which chosen you as a witness. This was about this scenario was in civil case. Now talking about criminal case, he may be awarded with fine up to rupees 500, imprisonment up to 6 months. A warrant may be issued to ensure his presence in the court. So these are the punishments: 500, 6 months, and warrant in criminal cases. Okay, fine. There is no such punishment in civil case, but you have to pay to the same party. Conduct money, very important, refers to the travelling and daily expenses to reach the court. In civil cases, normally it is paid at the time of serving the summon. It is paid by the party calling him. The summon in the civil case can be ignored if conduct money is not sanctioned. Fine. In a criminal case, no money is paid along with summons. The witness can ask for it after giving evidence, but he should not insist if the court is not willing to sanction, since otherwise he can be charged for contempt of court, which is insult of court. In simple words, if court wants to give money to you, it is going to give it. If it does not want, then obviously it would be denied. To an independent doctor, it is known as bhata, is always paid, while the doctor in government service can claim from this office. So just remember ki what is conduct money? Nothing. Traveling and daily expenses is it refers to the traveling and daily expenses made by the court, made by the party or say court, to reach the court, to give evidence in court. That is nothing but conduct money. Everything else, I think you people got that. Now what is preference? What would happen if I got 2 summons at a time? Or say if I got, let's imagine a condition, I got a summon, and in that very first thing I got 2 summons. Okay, one is of criminal case, second is of civil case. So which summon should I prefer? I would be preferring criminal case summon. So the point is given, criminal case is preferred over civil. Number 2, if both cases are criminal or civil, summon from higher court is preferred. Number 3, if both cases are criminal or civil from the courts of same status, the summon received earlier is preferred. The other court is informed accordingly. So I think you all people understood what are the preferences. 3 preferences, but remember to give preference to civil courts than to criminal courts than civil courts. And yeah, this was all about the what is summon, introduction, definition, penalty, conduct money, and preference. So you have to write this much of answer whenever you would be asked about SIQ about summon or subpoena. Yes. Now our second question is, what is the recording of evidence and cross-examination? So these are the 2 SAQs, separate SAQs, but we'll cover them both in one question. Talking about, we'll start with recording of evidence. After oath administration, the evidence is recorded under following 4 steps. Just now for this question, just imagine a scenario wherein 2 lawyers are defending for their, for their victim. Now, just imagine a scenario in court. You can also imagine any movie related to, any Bollywood movie also related to the court scenario. So let's say there are 4 steps every time. Examination in chief, direct examination, cross-examination, re-examination, and court questions. Very first thing, examination in chief. It is defined as the examination of the witness by the lawyer of the party calling the witness. In government prosecutions, it is done by the district government pleader or public prosecutor. Now, you just have to imagine you're a lawyer, okay. Now you have to call your witness in the witness box, and you just have to, explain the conditions and scenario, everything in the favor of witness, because the witness, or say the victim, whatever it may be. So it is nothing but the examination of the witness by the lawyer of the party calling the witness. For everything you do is for your victim at the end. So what you're going to do, you're going to call the witness which you have chosen for your victim, favoring you and your victim. So you'll be calling that witness, and you'll be explaining everything in the favor of victim. Basically you're just trying to describe your side to the judge. So that is nothing but examination in chief. Just imagine the scenario of any movie. Fine. Now what is the object, or say objective? To place before the court all the facts which are known to the witness. Okay, you'll ask the witness to expel everything that he or she knows, And if the witness is an expert, his observations and opinions are placed before court. Fine, very easy thing. I'll be asking my witness, okay, yes, Baba, whatever you know, you just have to tell in front of the judge about anything which happened related to the case. Okay, so this is nothing but examination in chief. What are the characteristics? Important characteristics. No leading questions are permitted. Now, what are leading questions? Leading questions are nothing but those questions which lead the witness to a desired answer, which means, example, is it true that the victim was hit at 5 p.m.? Is it true that the victim was assaulted with a knife? Is it true that the injury was on chest? So these are nothing but leading questions. You can't ask leading questions in examination in chief. In case the witness is declared hostile, leading questions can be asked. Now, what is hostile witness? Witness which changes his or her statement in front of judge. I mean, my witness would go against me in front of judge, so that witness would be called as hostile hostile witness. And leading questions can then be asked. Fine, if the witness is declared hostile, then you can ask leading questions to that witness. So we learnt about the examination in chief. It is nothing but you just describe it in your own words. But remember to write in points. Firstly, you have to write definition, then objective, and then characteristics, or say features. Coming to cross-examination now. First is examination in chief, second is cross-examination. What is definition? It is defined as the examination of the witness conducted by the lawyer of the opposite party. In government prosecutions, it is done by defense lawyer. So my opposite party would also be hiring a lawyer like me, or say, yeah, okay, fine. So another lawyer would ask the questions to my witness regarding the case. Okay, we all know this. What are the objectives? To establish truth by testing the accuracy of the statements made by witness, to extract out facts which are favorable to his party, to weaken the evidence given by the witness by showing that the details given are false. Basically, in simple words, he would be opposing my witness, and contradicting that and not based upon facts. So discrediting would be there. To remove the stress given on a particular point by forwarding other theories. So just diverting the attention of court. That is nothing but a thing done by opposite lawyer. Fine, lawyer of the opposite party. So this is nothing but cross examination. Cross is opposite, examination is anyhow you have to ask questions to my witness. Now leading questions are permitted in cross examinations. We'll see this. What are the features? Cross examination is the most important part of the recording of evidence as it helps to establish truth. Yes, leading questions are absolutely permitted. Now I can now the opposite lawyer can ask ki, was it true that the victim was hit at 5 p.m. and blah blah. So there is no time limit. That is, the same question can be asked repeatedly in different forms to extract out facts. We all have seen this in movies. In relation to an expert witness, his qualifications, experience, knowledge and skill can be challenged, though the judge may forbid or not allow any question that is unnecessarily offensive. So yeah, cross-examination acts as a double-edged sword. That is, it cuts both ways. That is, if the lawyer is not well prepared or does not ask questions carefully, while the witness is very well in his subject, the details elicited during cross-examinations may be further harmful to his own party. So what do we mean by this? If the opposing lawyer is not very well prepared, then whatever questions or whatever the answer would be or whatever information would be revealed by witness, then that would be harmful to his party. Okay, so opposing lawyer should be prepared. That is the only thing they want to say. So in cross examination, you will be writing definition, objective and features. In examination in chief, same thing, definition, objectives and features. Now we would be moving towards a re-examination. Now see, not my opposing lawyer. Okay, I am a lawyer and I also have got opposing lawyer. So I'll be answering now whatever question he raised in the court in front of everyone, contradicting to the facts which were told by my witness. Now I'll be re-examining that. I'll be explaining those points whichever he arised. Obviously, that is the same situation which happens in court. If my opposing lawyer is going to ask any question to my witness and he would be just deviating the subject and he would be just raising doubts so that the case favors to his side. So what I would be doing, I would be re-examining that, which means it is conducted like examination in chief, and so by the lawyer of the same party. I would be conducting it. So what is the objective? It is to clear out any discrepancies, doubts that have arisen during cross-examination. What are the features? Leading questions are not allowed. No new matter can be taken up except with the permission of judge and opposing counsel. On new matter introduced, re-cross-examination is permitted. This re-examination and re-cross-examination can go on any number of times with the permission of judge. So we just saw this. We all know this. Keep order and objection overruled. These statements are continuously going to happen in court, fine, in the scenario which they show us in movies. So that is nothing but re-examination, re-cross examination, and yeah, the process continues. Fourth point is questions put by the court. At any stage during the recording of evidence, the judge may ask questions to clear his doubts. So that is very easy. Just remember four things. What is recording of evidence? In simple terms, understand what the question is trying to say. If I got a question, what is recording of evidence? I know recording is recording, evidence is evidence. You just have to describe that it is nothing but, what do we say? Storage, or not storage actually. It is nothing but recording of the evidence only. It is taken in 4 steps. Directly start with 4 steps. I just wanted to tell you कि recording of evidence, if the question arises, no, start with definition of evidence. Whatever you know, like what is evidence? It is nothing but a proof, or say any important detail given to the court which would help the court to solve the case. In simple words, I didn't read this definition, I just made it by my own. So these definitions would, first thing, they help to, increase the length of your answer. Second thing, the examiner or the paper checker, this was told by one of the seniors to me, ki write from the, write word by word. Just take one word from the question, explain it first, and then start with your answer. I was told about this, so I just thought of sharing this with you people. Okay, moving forward to next question. This was about the recording of evidence, cross-examination. So what did we learn? 4 steps: examination in chief, cross-examination, re-examination, and the questions of court. Easy. Remember definition, objective, and features in every point. Fine. Moving to next question. Our next question is about inquest and difference between coroner's inquest and police inquest. So what do we mean by inquest? In means in, quasitus means is to seek. Inquest literally means to seek into, that is to look into, to find out. So what is the definition? In FMT, inquest is defined as judicial or legal inquiry into the cause of unnatural death. Two things you have to remember. Number one, it is a legal inquiry. Basically, it is an inquiry. And number two, that unnatural death. Remember the word unnatural death, that it takes place in unnatural death. So in forensic medicine, inquest is defined as judicial or legal inquiry into the cause of unnatural death. If death is natural, the dead body is handed over to the relatives for its disposal as per the religious customs. But if the death is unnatural, an inquiry is must to establish the cause of death, time since death, and the manner of death. You have to find out 3 things in case of unnatural deaths: cause of death, why did the person die; number 2, time since death; and number 3, manner of death, so that the guilty can be pinpointed and can later be punished. I think everyone got this. What are the types of inquest in USA and in India? In USA, they practice medical examiner system. In India, depending upon the officer who conducts the inquest, coroner's inquest, police inquest, and magistrate's inquest. But coroner's inquest is now stopped. We just have police inquest and magistrate's inquest. So starting, we'll learn about USA first. Okay, what is medical examiner system? In this system, inquest is carried out by medical people at the scene of crime or where the dead body is lying. However, he has no judicial powers like ordering arrest, etc. It is the best inquest in the world, MCQ, and is practiced in USA, Canada, and Japan. So nothing new in this medical examiner system. Medical officer is going to examine the scene. Easy. So medical people actually, they would be present at the scene of crime and they would be doing everything, examination, but they would not be they'll not have judicial powers like ordering arrest, etc. And it is the best inquest in the world. This is MCQ. Fine. This was about short introduction regarding medical examiner system. Now important question, Difference between coroner's inquest and police inquest. We'll learn about coroner's inquest first. It is stopped since 26/7/1999. It was carried out by a coroner. Who was coroner? Coroner is of the rank of class 1 judicial magistrate. Okay, now we'll be learning about the merits first. What are the merits? He does not have to inform anybody before doing inquest. Okay, can order exhumation. What is exhumation? Um, what do we say? Digging out the dead body if that dead body is buried. That is called as exhumation. Ex means out, humation means dead body, like that. Can order exhumation, can issue summons, records evidence on oath, can sanction conduct money, can issue warrant of arrest, can send viscera for chemical analysis, is assisted by jury which are qualified people and so more reliable. Coroner being qualified does not send all dead bodies for postmortem. Postmortem conducted by police surgeon who is better qualified and so report is better. Coroner being qualified is better able to judge the cause of death, and it is the best inquest in India, but it is now stopped. So these are the merits or say features of coroner's inquest. He has got all rights, mostly all rights, and he can order exhumation also, can issue summons, everything coroner can do. Coroner try to do, and yeah, these are the merits. What are the demerits? It was conducted only in the city of Mumbai, conducts inquests in his court, cannot directly arrest the guilty. So this is the demerit, that he or she cannot directly arrest the guilty. Just remember the points. Now we'll now talk about the police inquest. Then at the last we'll be comparing both of them. So what is prevalence? It is carried out by PO, police officer. PO is of the rank of head constable or above. What are the merits? It is the commonest inquest in India. It is conducted throughout the country except regions where the magistrate's inquest is to be done. We'll see those reasons. Conducts inquest at the place where the dead body is lying. Can himself arrest the guilty in cognizable offences. What are the demerits? The police officer has to inform the executive magistrate before proceeding to the place where the dead body is lying. But coroner does not have to inform anyone. Police officer cannot order exhumation. He cannot issue summon. He cannot, record the evidence on oath. He just records statements. He cannot sanction conduct money. He cannot issue warrant. He cannot send viscera for chemical analysis. He is assisted by panchas, usually illiterate and chosen at random, so less reliable. The police officer usually sends all the dead bodies for postmortem, thus unnecessarily increasing the workload of MO. Then it is done by any MO. What postmortem is done by any MO, and police officer is not qualified, to judge the cause of death. And this inquest is usually poor in India. So these were the differentiating points between coroner's inquest and public inquest. Police inquest. Police inquest, if you'll start imagining any situation of crime or say crime scene, then just write whatever you think. We all know this, that it is the commonest inquest. We also know that police officer conducts inquest at the place where the dead body is lying. So these are the simple points. We just have to recollect those points while writing. Read this once and we all would be able to write this. Talking about magistrate's inquest as per section 176 ERPC definition, it refers to the inquest carried out by an executive magistrate, district magistrate or subdivisional magistrate. So we have executive magistrate, district magistrate, which is collector, or subdivisional magistrate. It may be in place of or in addition to police inquest. Either police inquest is completely, police inquest is not conducted at all, or it is conducted in addition to the police inquest, depending upon the situation. What are the indications? When police officer himself is a suspect, death during police interrogation, death during police custody, death in jail, and death during police firing. Number 2, in case of gross fallacies in police inquest, mistakes. Number 3, in case of buried dead, since a police officer cannot order exhumation. Okay. In cases of dowry death, death of a married female less than 30 years of age, or death within 7 years of marriage. This is again a question. When government orders this inquest. So these are the points, these are the 5 indications under which magistrate's inquest is carried out. Just remember, when police officer himself is considered as suspect, how are you going to allow him to do the inquest? So where magistrate inquest is carried out, and in case of gross mistakes, exhumation, dowry death, and when government orders this inquest. So these were the points regarding your magistrate's inquest and your difference between coroner's inquest and police inquest. How many points? 12 points. Remember, you have to write 12 points regarding demerits and merits, and more than 12 points actually, in case of differentiating coroner's inquest and police inquest. So this was all about the inquest. Moving to next question. Yes, now next question is about what the question says, what is medical evidence, define medical evidence, what are the types of medical evidence, and you have to describe the documentary evidence. Fine. So starting with medical evidence, well, this is another question actually. What is a medical evidence? Evidence refers, and now just you start with the definition of evidence. Evidence refers to written documents and oral statements on oath which help the court to decide a case, and when the evidence refers to medical science, it is known as medical evidence. Easy. Whenever there are written documents and oral statements taken on oath, and those things just help to solve the case, which help the court to decide a case or solve the case, then that is nothing but your evidence. But if this thing occurs in refers to medical science, then it is medical evidence. Just any evidence containing any information regarding to medical sciences is nothing but medical evidence. Now what are the types? Basically medical evidence is divided into three types: written, oral, and circumstantial. Written is also called as documentary, fancy name. Written is again subdivided into four types: medical certificates, which we get which we were asked to submit at the time of admission process. You remember, fitness certificate and sickness certificate, and yeah, so these were the medical certificates. I just gave examples so that you people can relate. Number two, medical legal reports. These are not for us. Dying declaration, dying deposition. So these are the four subtypes in written documents, or say written category. Second is oral or parole, which is direct and indirect, and circumstantial. Now starting with written and documentary, it refers to the hospital medical records, lab records, radiological records, medical certificates, and medical legal reports prepared by a medical officer, and which can be used for administration of justice. Obviously, why? What is the need to prepare these reports and certificates? These are used for administration of justice as a proof, as an evidence. So why these are called as medical evidence? Easy. So what is written or documentary? Nothing. You just enumerate this, write it in order: medical records, lab records, radiological reports, medical certificates, medical legal reports. And these reports are prepared by whom? Obviously by us, medical officer, and which can be used for administration of justice. Fine. Now what are medical certificates? This was about the intro of written documents, or say written category of medical evidence. Now what are medical certificates? These are the simplest type of written medical evidence and refer to the certificates which are issued by the medical officer at request of the patient or his relatives in one of the following situations. So basically simplest type of written document it is, and it refers to the certificates which are issued by the MOs, medical officers. So in which situations? Sickness certificate we have, fitness certificate, vaccination certificate, disability certificate, which is compensation certificate, birth certificate, and death certificate. So at the time of admission, we were asked fitness certificate, I guess. Yes. So sickness, fitness, vaccination, compensation, birth, and death. So these are about the medical certificates. Now there are certain precautions. You just can't blindly, in future, some patient or few patients would ask you ki ma'am or sir, I want medical certificate, I want sickness and fitness, so just give me the certificate. So you're not going to blindly sign the certificate, because it would turn out to be some crime in future if the person was already a murderer or criminal. We don't know, no? So what are the precautions? Precautions to be taken by a medical officer while issuing medical certificates are: medical certificate can only be issued by RMP, registered medical practitioner, and should carry his signature, name, designation, and registration number. So your entire kundali is going to be present on that medical certificate, so you just have to be very careful. In all certificates, name, age, sex, address, and 2 marks of identification of patient should be written. Practically, signatures, left thumb impression. So practically, what do we take? We take signatures, left thumb impression, and scars, moles, or tattoo marks on preferably exposed body parts are written. Certificates should always be based upon observations and never on history alone, as they can be used as evidence. So you just have to take a thorough um, history as well, and you just have to observe the patient carefully also. Issuing false certificates is punishable under section 197 IPC. uh, just try to find out the BNS section of this also. The medical officer should never keep the blank prescription and certificate signed in advance. Anyone can misuse them. A copy of certificate issued should be retained by the MO. This for proof, for the safety of MO, okay, in future. The certificate should always be complete and therefore mention necessary details like in sickness certificate, exact nature of illness, duration of illness, period of rest advised. In fitness certificate, it should be nature of illness from which he was suffering, duration of suffering, that he is now fit to resume his duty, mention his occupation. So you just have to remember, you just have to be careful with the format and details. Vaccination certificate, name of vaccine, batch number, date of vaccination, disability, nature of disability, cause of disability, percentage disability, and whether it is permanent or temporary. In birth certificate, name of mother, date and time of birth, and place of birth. So these are the things which we write in. These are the things which come under the medical certificates. We are just now we are at written and documentary category of medical evidences. We still have two categories, oral and circumstantial. So now what did we read? We read about the medical certificates subcategory of written evidence, written medical evidence. Now we will be moving forward. And what is death certificate? So death certificate is nothing but it refers to the certificate certifying death of person. It is issued by routinely the death certificate is issued by the RMP who has attended the last stages of the life of patient, that is in whose presence the patient died. Therefore, if the patient is brought dead to the hospital or dies unattended, the death certificate cannot be issued. In this situation, it is given after PM. Remember this point, it is very important and it is very it is very crucial to understand the importance of this statement, because if you're just blindly giving death certificate to everyone out there, then obviously it is going to cause trouble to both doctor as well as the one issuing the certificate. In case organs are to be removed from the dead body for organ transplantation, two death certificates should be prepared by the two separate MOs who should not be members of the transplant team. Those MOs should not be members of transplant team. These are the points regarding the issuing of the death certificate. What is death certificate? It refers to the certificate certifying the death of person. Now what are the precautions? Every certificate has got certain precautions. So while writing answers, try to elaborate what that certificate means. Try to define the certificate in simple words, in your words. Then try to write about the authority of a person who can issue that certificate, and then you just have to do not forget to write the precautions. It will increase the length of answer, as I said it many times earlier, and it looks better. So what are the precautions while issuing death certificate? Ensure that the patient is dead. The present criteria to diagnose the death is brainstem death, evidenced by absence of voluntary respiration, absence of all cranial and motor responses, abolition of all reflexes. Death may be wrongly diagnosed in suspended animation, that is, vital functions of the body are at such low levels that they cannot be diagnosed by routine clinical examination. Voluntarily, it can be induced by sadhus and yogis, and involuntarily, it may be present in cholera, typhoid, tetanus, drowning, electrocution, and sometimes in newborn babies. So just take precaution that the patient should be actually dead, because many cases are noted about suspended animation and the doctor may be sued for that. So ensure that the death is natural, since if it is unnatural, inquest has to be carried out and the body has to be sent for PM. You can issue death certificate only and only if the death is natural. If it is unnatural, then the proceedings would be carried out, inquest valley proceeding and your PM valley proceeding, which is post-mortem. If death is natural, the death certificate has to be issued without any delay, without charging any fees, and even if the professional fees is not paid, also mentioning the exact cause of death. So this was about the points regarding precautions. A few more points. The death certificate should never be issued at the request of the relatives of the patient and without examining the dead body. Do not prescribe it blindly. In some hospitals, the death certificate is to be countersigned by the medical superintendent or civil surgeon. Legally, it is unwanted. Even if it is to be done, it should be done after the personal examination of the dead body. Death within 24 hours of administration or during or after the operation is routinely a medical legal case, and it should be informed to the police. However, if the cause of death is obvious or death is not related to the operation, death certificate can be issued. So what they are saying is, if the death occurs before the operation or after the operation within 24 hours, police has to be informed, because that turns out to be MLC. But the cause of death was already known. It was very certain that the person is going to die anyhow, and if the cause of death is not at all related to the operation, then surely you can, give death or issue death certificate. Contents: name, age, sex, address, 2 marks of identification, name of hospital and doctor, place, place, date and time of death, exact cause of death, mention the condition causing death. Also describe the contributory factors. Giving cardiorespiratory arrest or cardiac arrest as the cause of death is wrong, completely wrong. You have to mention the condition which is causing death, which caused death. You have to describe the contributory factors. What is the importance of death certificate now? It is required for registration of death since from 1/4 in 1969. The registration of birth and death is compulsory for basically PSM purpose. It is given in community medicine, I guess. Regarding surveillance, or I say no, I don't know. Anyway, skip that part. Death certificate is required for the registration of death. Fine. Cremation of dead body, settlement of insurance claims or pension claim, and transfer of property to relatives. Okay, execution of the will of the dead. So these are the 5 points you need death certificate in that. DC in that: registration of death, cremation of dead body, settlement of insurance claims or pension claim, and transfer of property to relatives, execution of the will of the dead. Just try to figure out in which system in community medicine we register the birth and deaths by our own. I think that is civil registration system, something. Just confirm it once. Okay, so this was about the importance of death certificate. Now we all saw what death certificate is. Yeah, this was about the medical evidence. This was about the medical certificates actually. Now we are good to go with medical legal reports, dying declaration, and dying deposition. Just three points are remaining. We'll just quickly I'll just quickly read medical legal reports. They are defined as the reports prepared by an RMP at the request of the investigating officer or the court. Remember the thing, it is a medical legal report. It is not medical certificate that anyone will come and ask. No, it is medical legal. That means court and investigating officer would come in role. They are defined as the reports prepared by the RMP at the request of the investigating officer or the court. The report is considered as evidence only after the doctor attends the court and testifies to the facts under the oath. Fine. Then and then only the report is considered as evidence. Examples of medical legal reports are age report, injury report, poisoning report, burns report, alcohol report, report of examination of victim or accused of rape, importance report, insanity report, or P. Now, what are the precautions? Precautions to be taken while preparing medical legal reports are: can only be prepared by RMP. Report should be based upon observations only. Report should be prepared during examination or immediately after the examination and should carry the signature, name, designation of MO. It can only be prepared by registered medical practitioner. It should be based upon observations only, and it should be prepared immediately after the examination and should carry the signature, name, and entire kundali of that MO. No adjectives specifying personal feelings should be used, that is cold murder, big injury, extensive hemorrhage, poor victim, etc. Any medical legal report has 3 parts: preliminary data, observation, and inference. Preliminary data: number and date of the requisition letter from the police station, name, age, sex, address, brought from, brought at, date, time, and place of examination, name of the hospital, name of MO, consent for examination, 2 marks of identification, and history of the case. So these things come under the preliminary data, just name and introduction and everything. Number 2, observation, report of examination, that is report of examination, what exactly you observed in that patient. And number 3, your opinion. So any atom, weapon, clothes, bone, or photograph sent for examination is examined, described in report, marked, sealed, and returned to the investigating officer under receipt. So these were the 6 points under medical legal reports. Remember, medical legal reports are always and every time issued at the request of the investigating officer and the court, not on the request of relatives and patients, friends or family, etc., because it is a medical legal report. So this was the main difference between your medical legal report and medical certificate. Fine. Remember to take the precautions, 6 precautions. Yes. Now we'll be learning about the dying declaration. What is dying declaration? Dying declaration is defined as a written or verbal statement made by a person likely to die because of some unnatural act done. 3 things to remember in this definition. Number 1, it is written or verbal statement. Number 2, made by the person who is going to die. Number 3, because of some unnatural act, not natural act. So this is about the dying declaration. More about dying declaration. Made by a person likely to die because of some unnatural act done on his body, narrating the circumstances or the conditions responsible for his present state of health or the cause and manner of likely unnatural death. Anything which is describing the cause and the manner of likely unnatural death, that is, which means after few minutes or after few seconds that person is going to die, and you know that you are so sure by seeing that patient or person only, you get to understand ki yes baba, that this death is going to be called as unnatural death, this is not a natural death. So that observation or that confirmation should be included in the definition of dying declaration. So anything which defines or which states that the person has gone through some kind of trauma or any injuries which has caused the present state of the health of that person, cause and manner of likely unnatural death. What are the precautions? The precautions taken are, while recording dying declarations, ideally dying declaration should be recorded by executive or honorary magistrate. This is MCQ, remember, executive or honorary magistrate. Doctor has to certify the patient to be compos mentis. During recording, no relatives are allowed to be present. During recording, no police officer is allowed to be present. No oath is administered because the person is going to die in few seconds. Leading questions are not permitted. It is recorded in presence of 2 disinterested witnesses. It is recorded in question answer form. It is recorded in vernacular of patient, his home language. At the end, it is signed by magistrate if present, the patient, the doctor and the 2 witnesses. So these were the points, these were the precautions taken into consideration while recording the dying declaration. Remember the point that it should be ideally recorded by executive or honorary magistrate. Now, what is procedure of recording? Dying declaration refers to written or verbal declaration made by the patient likely to die, narrating the cause of his likely unnatural death. Obviously, anyone who is dying would try to tell people or would try to reveal the reason or say cause of death behind his or her unnatural death. It is not necessary that the patient should be sure to die, though as per English law, the dying declaration is recorded only if death is certain. See, if you are sure that the person is going to die after few seconds, then and then only you have to record the dying declaration as per English law. Ideally, dying declaration is to be recorded by executive or honorary magistrate, HM, but if executive or honorary, forget that word please. Ideally, dying declaration is to be recorded by executive magistrate, but if magistrate is not available or there is not enough time to wait for him, the dying declaration should be recorded by the doctor himself. If the patient is not in hospital, dying declaration can be recorded by any person present near the patient. Okay. If the patient is not in hospital, dying declaration can be recorded by any person present near the patient. In cases of dowry death, it is essential that dying declaration should be recorded by the magistrate only. Remember the point in magistrate inquest also we learned कि dowry death occurs, dowry death investigation is taken under magistrate's inquest. Before recording of dying declaration, the patient is examined and certified by the MO to be compos mentis, that is in composed state of mind, which means during the procedure of recording of the dying declaration, the person should be in sound mind, that is composed state of mind. Then and then only it is considered as valid. So what did we learn about the procedure of recording? Number one point, it is not necessary that the patient should be sure to die, but according to English law, it is recorded only when the death is certain. Then if the person again, somehow the person is saved, then dying declaration is not considered as valid, because the name itself is suggesting that it is dying declaration. Ideally, second point, what did we learn? Second point, ideally dying declaration is to be recorded by executive or honorary magistrate. But if magistrate is not present, then doctor can record the dying declaration. And if the patient is not in hospital, relative can record the dying declaration. And in cases of dowry death, magistrate is only allowed. The patient should be in compos mentis state. So this was about the everything about the dying declaration. A few more points about the procedure in dying declaration is, how many points are remaining? Yeah, this is going to be our last image. So what are the precautions? I told you the person should be in compos mentis, that is in composed state of mind, that is in sound mental condition, so that the patient can understand the questions put to him and can properly answer them. All attempts should be made to encourage the patient to write what he wants to inform. If he cannot write, then verbal statement is recorded. During recording, no relative or police officer is allowed to be present, since they may influence the patient. No oath is administered and no leading questions are permitted. Dying declaration is recorded in the presence of two disinterested witnesses in question and answer form in vernacular of the patient, that is the exact words spoken by the patient are written in the language of the patient without any translation. After recording, the doctor again examines the patient for being compos mentis. The contents of the dying declaration recorded are read over to the patient, and it is certified that the contents are read over to the patient and he agrees with them. The date, time, place of recording is noted. Declaration is signed by the magistrate, doctor, the patient and the two witnesses. The report is sent to the magistrate in a sealed cover. So this is all about the procedures before and after recording of the dying declaration. Now, what are the special circumstances? If the patient cannot write, example in cases of burns, his oral statements are recorded. If the patient can neither write nor speak, example cut throat injury or cases of poisoning, signs and gestures made by the patient are recorded. If the magistrate or the doctor does not understand the language of patient, the help of third person is taken. If the patient dies during recording, the doctor examines and certifies that the patient to be dead, and then the incomplete dying declaration is signed by all the concerned. So these are the four special circumstances. Now what is the importance? The importance of recording dying declaration is, as per section 32 and 157 of Indian Evidence Act, every person during last stages of life speaks total truth. Therefore, great sanctity is attached to dying declaration. It is regarded as an important evidence in that case. Number 2, if the patient does not die after the recording of the declaration, the dying declaration loses its importance, since now he can be called to the court and his evidence can be recorded after cross-examination. If the patient survives for a few days after recording, the dying declaration retains its full value. Okay, now talking about dying deposition. So there is one question which states differentiate between dying declaration and dying deposition. So remember, dying deposition is not at all followed in India. What do we follow? We follow dying declaration only. What is definition? It is defined as a deposition statement on oath made by a person likely to die because of some unnatural act, narrating the cause of his likely death to the magistrate in the presence of accused and lawyers of both the parties who can cross-examine the patient. Very important thing, lawyers are permitted, cross-examination is permitted, accused and victims are permitted. So everything is permitted in dying deposition, but in dying declaration, police officers are not, even police officers are not permitted. So this is one differentiating point. Number 2, precautions and procedures. Dying deposition has to be recorded by the magistrate in presence of accused and lawyers of both the parties. And who copies or who records dying declaration? Executive magistrate. In absence, doctor. In absence, relative. Fine. Doctor has to be present throughout the procedure and has to certify that the patient is at compos mentis at the beginning and at the end of the recording. Any person may be present during recording. Oath is administered to the patient. Cross-examination includes leading questions. No witness is required. Recording is done as per the procedure of the court, and therefore it almost means that the court is present at the bedside of the patient. What is the importance? Dying deposition is more important than dying declaration because it is recorded by the magistrate in presence of accused, in presence of lawyers of both parties, and it's recorded after cross-examination. So it retains its full value even if the patient does not die because cross-examination has already occurred. So in importance, we give more importance to dying deposition, but unfortunately it is not practiced in India, so not to worry about that. But in MCQ it is oftenly asked who has got more value, dying deposition or dying declaration. So dying deposition has got more value because entire court is present bedside to the patient, at the bedside of patient. And what are the precautions? Same precautions like dying declaration, but everyone is allowed during the dying deposition. And yeah, a third important point is in dying deposition, even if the patient is recovered after recording the dying deposition, then that dying deposition has got full value, but that is not in the case of dying declaration. So yes, now we have completed our very first chapter, Introduction and Legal Procedures. Important questions from this chapter are completed, and I want you people to revise the answers of these 6 questions. And yeah, just pause the video, read it carefully, read it slowly, and you can also increase the speed of video according to your convenience. So yes, we have completed our introduction and legal procedures. The video is quite lengthy, I know, but I can't help. And yeah, it is going to be beneficial for your revision. And we are good to go for second video then. Second video would be on medical jurisprudence. Till then, keep learning, keep growing. See you in the next video. Bye.